So let's now talk about donations. Donation, according to Article 725, is an act of liberality, whereby a person disposes gratuitously of a thing or right in favor of another who accepts it. The Code defines it as an act. If you look at donations, however, it might be more accurate to consider it not just as an act, but as a contract. Why? Because it requires not just the act and consent of the donor, it always requires the acceptance on the part of the donee. Without an acceptance, you do not have a valid donation. Only an owner of property can donate it. A non-owner cannot donate. If property is donated by somebody who is not the owner of the property, that is not a valid donation. Although, of course, that may provide the basis for the acquisition of ownership, not through donation, but through prescription. Acceptance is necessary. Without acceptance, there can be no valid donation. Whether the donation is mortis causa or inter vivos, there must be acceptance. If the donation is a donation mortis causa, the acceptance can only be made after the death of the donor. An acceptance of a mortis causa donation before the death of the donor would be clearly premature. There are 4 principal types of donations, according to one classification, based on the purpose or cause, 4 types. First, you have the pure or simple donation. That is a donation which is essentially and exclusively gratuitous in character. No conditions, not intended to remunerate another person, simply born out of the generosity of the donor. Simple or pure. And then you have the remuneratory or compensatory donation. This is intended to remunerate or compensate another person, the donee, for past services, which, however, do not constitute demandable debts. You have a classmate who has always been helping you study for your daily recitations. Whenever you're reciting, nasa likod mo yan, bubulong-bulong ng tamang sagot. At pag may examen naman, kunwari medyo babasahin yung kanyang sagot para makita mo. If you donate later on in life, milyonaryo ka na. Naalala mo yung classmate mo. O kung hindi yung classmate ko yun, hindi ako nakatapos ng law. If you donate property to that classmate of yours, that will fall under the category of a remuneratory donation because it is intended to somehow recompense your classmate for past services which do not constitute demandable debts. The third type of donation is the so-called modal donation, sometimes called conditional. Here, the donation is made in consideration of future services. Yung remuneratory, past services. Dito, the donation is made in consideration of future services. Or the donor imposes certain conditions or charges where the value of the property donated is more than the charges imposed by the donor. Because if the value of the property donated is equal to or less than the amount of charges imposed by the donor, then it would fall under the 4th category. It would be an onerous donation. And there would be a very important legal consequence if it is an onerous donation. Because an onerous donation is not in reality an act of generosity. Consequently, it will be governed not by the law on donations, but by the law on contracts. So again, when is the donation considered onerous? If the value of the property donated is equal to or even less than the amount of charges or the value of the conditions imposed by the donor. Onerous na yan. If that happens, you apply the law on contracts rather than the law on donations. Another important classification of donations is the classification between donations inter vivos and donations mortis causa. Remember one very, very important rule. If it is a donation mortis causa, what is the form you have to observe? the form prescribed for wills. You can only have a valid donation mortis causa if you execute a valid last will and testament. When would it be a donation inter vivos? When would it be a donation mortis causa? If the donation is to take effect during the lifetime of the donor, it is a donation inter vivos. If it will take effect only after the death of the donor, it is a donation mortis causa. If the donor, in the deed of donation, prohibited the registration of the donation before his death, sabi niya, I'm donating this property to the donee, but the donee is prohibited from registering this donation before my death. What kind of a donation would that be? Mortis causa. A prohibition against registration before the death of the donor makes it a donation mortis causa. If the donor reserves the usufruct of the property, I donate this property to so-and-so, but I hereby reserve the usufruct of this property which I'm donating until I die. Mortis causa or inter vivos? Inter vivos yan. In other words, the property has already been donated. It's only the usufruct which is retained by the donor, but ownership would have already been transferred. If the donor says in the deed of donation, I'm donating this property, but I hereby reserve the right to revoke this donation anytime before my death. Maliwanag yan. As long as there is a reservation on the part of the donor of the right to revoke due to any cause, anytime before his death, that should be considered as a donation mortis causa. Sabi nga ni Justice J.B.L. Reyes, that's one of the characteristics of a donation mortis causa. If the donation is revocable at will, ad nutum, anytime before the death of the donor, that's one of the distinguishing marks of a donation mortis causa. If the donor granted the donee a limited right to dispose, sabi ng donor, the donee may dispose of the donated properties only if it is necessary to raise funds for my support. Limited right to dispose. Is that a donation inter vivos or mortis causa? It has been held by the Supreme Court. That is a donation inter vivos. If the document is titled as a donation mortis causa, nakalagay, deed of donation mortis causa, and it is clear in the deed of donation that it is being made for services rendered and still being rendered by the donee, and it is provided that the donee shall take possession only after the death of the donor, with the obligation to have a certain number of masses for the repose of the soul of the donor. Is that inter vivos or mortis causa? Sabi ng Supreme Court, that's a donation inter vivos. In one case, in the deed of donation, the donor prohibited the donee from disposing of the donated property within 10 years from the death of the donor. So sabi, okay, I'm donating this property, but for a period of 10 years, counted from the time of my death, you cannot dispose of these properties. Mortis causa or inter vivos? That's a donation. Mortis causa. Sabi ng Supreme Court. In one case, the donor made a warranty. He warranted in the deed of donation that nobody will disturb the donee or question the donee's right. Inter vivos or mortis causa? Inter vivos. Because the warranty made by the donor implied that title to the property has already been conveyed. In another case, the donor said in the deed of donation, the properties cannot be disposed of in any way without my consent. Mortis causa or inter vivos? Mortis causa. The donor, of course, is allowed to impose conditions to which the donation would be subject. Of course, if he imposes impossible or illegal conditions, these are not considered imposed. In other words, impossible or illegal conditions are simply ignored. They do not affect the validity of the donation. You remember in this connection that the rule is different in the case of obligations. If an obligation is made to depend upon an impossible or illegal condition, not just the condition but the obligation itself is rendered invalid. The rule is different in the case of donations as well as in the case of testamentary dispositions. What's the reason for the difference? because donations and testamentary dispositions are principally based on the generosity, the liberality of the donor. In one case, you remember, this involved the Roman Catholic Archbishop of Manila. Property was donated, and the condition was that the property shall not be alienated for 100 years. 100 taon, hindi pwedeng i-alienate. That was considered as an illegal condition by the Supreme Court. That is an unwarranted and undue restriction on the rights of ownership. Next point. When is a donation perfected? The law is very clear. A donation is perfected from the moment the donor knows of the acceptance by the donee. In this connection, you also remember that under Article 737, the donor's capacity shall be determined as of the time of the making of the donation. So, the capacity of the donor will have to be determined as of the time he makes the donation. When is the donation deemed made? When is this moment called the making of the donation? It is at the moment when the donation is perfected. And when is that moment of perfection? At the moment that the donor knows of the acceptance by the donee. That is the moment of perfection. And therefore, the donor must have capacity at that time. If the donor signs the deed of donation when he was insane, in other words, incapacitated, the donation was sent to the donee who, in due time, decides to accept it in the proper form, and the acceptance is sent back to the donor. When the acceptance is delivered to the donor, he was already sane, matino na. Is there a valid donation? If we apply these provisions literally, it would seem that yes, there would be a valid donation. Because, to repeat, the capacity of the donor is determined as of the time of making of the donation. At ang sabi natin, when the law speaks of the making of the donation, that can only refer to the moment of perfection. And the moment of perfection is that moment when the donor has knowledge of the acceptance by the donee. But what about the donor? If you happen to be the donor in that case, syempre, sira ulo mo. You don't know what you're doing. Pirma ka ng pirma lang. Sira nga ulo mo eh. Tapos, one day, bigla kang tumino. Datingan ngayon yung mga acceptance. Yung pala, pinagdodonate mo na yung kung ano-ano mga properties mo. Do you think it would be fair insofar as you're concerned to be left without any possible remedies? I do not think so. I think that in that case, the donor should be allowed to question the validity of the donation. After all, he was not really capacitated when he signed the donation. Hindi niya alam. He was precisely insane. As a matter of fact, I think we can even find guidance in the provisions of Article 1323, the Civil Code. Under the general rules on contracts, an offer becomes ineffective upon the death, insanity, insolvency, or civil interdiction of either party before acceptance is conveyed. Under that provision, even assuming that both parties were capacitated, but after the offer was made, either one of them dies or becomes insane or is placed under civil interdiction or becomes insolvent, the law says automatically the offer becomes ineffective. I think we can apply the principle under that provision even in the case of donations. With more reason, if at the time the offer of donation was made, the donor was already insane. Remember the donations which are considered void under Article 739. Number one, of course, those made between persons who are guilty of adultery or concubinage at the time of the donation. Second, those which are made between persons found guilty of the same criminal offense, where the donation was made in consideration of the said offense. And third, those made in favor of public officers or their spouses. Ang sabi ng law, wife. Paano kung husband? Yung word na wife in Article 739 should be understood to mean spouse, descendants or ascendants by reason of their office. I have always maintained that this provision is useless. Why? Sino ba naman ang siraulong public officer who will agree to receive a bribe in the form of a donation na may paper trail and everything? Siyempre, COD yan, yung mga ganyan transaksyon. Anyway, you have this provision under Article 739, the Civil Code. Remember that minors and all other persons who cannot enter into contracts may be the donees in donations, but the acceptance should be done through their legal representatives. Even unborn but conceived children can already be donees. Remember that those who are still in the womb are already deemed born for civil purposes beneficial to them under the provisions of the Civil Code. Under Article 744, I call your attention to the supposed rule under the Civil Code on double donations. Sabi ng law under Article 744, if the same property is donated to two different persons, the rule on double sales will apply. Okay. There is something wrong with this provision. Why? Because it seems that the codifiers forgot that donation by itself is a distinct mode of acquiring ownership. What do I mean? If I donate property to Mr. A, and later on I donate the same property to Mr. B, it is obvious that if the first donation is valid, I cease to be the owner of that property. It's already owned by Mr. A, the donee. If I donate that same property to Mr. B, walang question. The second donation is obviously invalid because only the owner of property can donate it. Yan ang problema ng Article 744. The acceptance must be made by the donee himself or by a person who is properly authorized to accept. Otherwise, the donation is void. And with respect to donations inter vivos, the acceptance must be made during the lifetime of the donor and of the donee. The forms for valid donations are stated in Article 748 and 749. You distinguish between personal and real property. With respect to personal property, even an oral donation is valid. But an oral donation of personal property requires the simultaneous delivery. If the value of the personal property donated, however, exceeds 5,000 pesos, for the donation to be valid, the donation as well as the acceptance must be in writing. Kahit na sa kapirasong papel lang, as long as it is in writing. Otherwise, if the donation or the acceptance is not in writing and the value of the personal property donated exceeds 5,000 pesos, the donation is void. When it comes to real property, regardless of the value, the real property donated may be worth only 200 pesos, a few square meters of land located in the hinterlands, in a remote barangay, somewhere in the middle of nowhere, value 200 pesos. Regardless of the value, you always need a public document for the valid donation of real property. The acceptance must be made either in the same instrument or in a separate instrument. If made in a separate instrument, the acceptance must be noted in both instruments and the donor must be notified thereof in an authentic form. That's very clear in Article 749. In one case, however, I refer to Pajarillo versus Intermediate Appellate Court. The Supreme Court, I think, is speaking through Mr. Justice Isagani Cruz, refused to strictly apply Article 749. What happened in that case was that there was a donation involving real property and the acceptance was made in a separate instrument. Unfortunately, the law requires that if the acceptance is made in a separate instrument, the donor must be notified thereof in an authentic form and that step must be noted in both instruments. In the Pajarillo case, there was a failure to note that step in both instruments. Hindi na i-note do sa both instruments that the donor had been notified in an authentic form. Sometimes it's called yung constancia authentica. There was a failure to note that. The Supreme Court, however, refused to apply strictly the provisions of Article 749 because according to the court, if the provision will be applied strictly, it would result in injustice. And it would also result in a distortion of the intention of the donor. All right. What may be donated? You may donate everything you own as long as you reserve, either in usufruct or in full ownership, sufficient property for your own support as well as for the support of people legally entitled to get support from you. That is the general limitation. If you do not observe that limitation, you donated everything without reserving sufficient properties for your own support or the support of people legally entitled to get support from you, the donation may be reduced on petition of any of the persons affected. A donation cannot comprehend future property. When is property considered future property? If it is property which the donor cannot dispose of at the time of making the donation. Is there a right of accretion in donation? General rule, no accretion. Exception, if the donees are spouses, unless otherwise provided by the donor. When would there be accretion in donation? I submit there would be accretion under the same circumstances as in the case of testamentary dispositions, meaning to say RIP, in case of repudiation, refusal to accept, incapacity, or predecease. But the general rule is that if there are several donees, there is no right of accretion, except if the donees are spouses, in which case there would generally be accretion, unless, of course, provided otherwise by the donor. In the case of reversion, remember the rule under Article 757. Reversion may be validly established in favor of the donor in any case and circumstances. For any case or circumstances. Pwede, basta the reversion is in favor of the donor. If it's in favor of other persons, it can only be validly made if the persons are living at the time of the donation. If the provision on reversion is invalid, it does not comply with the requirements of Article 757, only the provision on reversion is voided. The donation remains valid. I donate property to Mr. X, but I provided for reversion in the deed of donation. Sabi ko in the deed of donation. Upon the death of Mr. X, the property will revert to me. Valid yun, because I'm the donor. If I say in the deed of donation, I'm donating this property to Mr. X, but upon the death of X, the property donated will go to the firstborn child of my brother Jose. At the time of the donation, yung kapatid kong si Jose, wala pa namang anak. That's not a valid reversion because at the time of the donation, the intended recipient in case of reversion is not yet living. But in that case, there would still be a valid donation. Only the provision on reversion is considered void. Is the donee obligated to pay the debts of the donor? The answer is no. If there is no order from the donor for the donee to pay the debts of the donor is not obligated to pay the debts of the donor. Of course, if the donation was made in fraud of creditors, then regardless of whether there is an order or not, the property donated can be made liable for the payment of the debts in favor of the defrauded creditors. And in that regard, you remember that in case of donations in fraud of creditors, the good faith of the donee will not protect him. Even if the donee is in good faith, that will not protect him. The creditors would have the right to proceed against the property donated. Why? Because unlike in the case of transfers by onerous title, in the case of a donation, it is purely gratuitous. Wala namang nawala sa donee. So even if he's in good faith, the good faith of the transferee will not protect him if the transfer is by gratuitous title. If there is an order to pay the debts of the donor, sabi ng donor, the donee is hereby ordered to pay my debts. It is understood that that applies only to pre-existing debts of the donor. It will not cover debts which are incurred by the donor after the donation. Yun lang mga existing debts niya. So let's now go to the matter of revocation. Siyempre, tandaan natin dyan yung Article 760. Situations when a donation may be revoked or reduced. Ang memory guide natin is BAR. Birth, adoption, reappearance. If at the time of the donation, the donor did not have any children or descendants, sabi ng law, the donation may be revoked or reduced if subsequently he should have children. Or if a child which he thought was dead should turn out to be living, reappearance. Or in case he adopts a minor child. What is the prescriptive period? 4 years under Article 763 for the revocation or reduction of the donation under Article 760. It will be revoked or reduced only to the extent that it is inofficious. It will be inofficious only if it exceeds the so-called free portion of a person's estate. In other words, if it would impair the legitim, taking into account the estate of the testator at the time of the birth, appearance, or adoption of the child. Please take note that the reduction of the donation under Article 760 does not happen automatically. Hindi yan automatic. There must be a corresponding case filed for the revocation or reduction of the donation. And still in connection with Article 760, in connection with Article 761, you please take note that in one case, the Supreme Court categorically said, there will be no revocation, no reduction of the donation, even in case of birth, adoption, reappearance, if there is no allegation and proof that the legitim has been impaired. In other words, the ultimate basis of Article 760 is impairment of legitim. Kung walang impairment of legitim, it is not even alleged. Or if it is alleged, it is not established or proved. There is no basis for the revocation or reduction of a donation. So, prescriptive period, 4 years. The action cannot be renounced. And it is transmitted upon the death of the donor to his legitimate and illegitimate children and descendants. Now, you take note of Article 764. This time, revocation is based on non-fulfillment of a condition. Remember, the donor may impose conditions. If the donor does not comply with the conditions, the donation may be revoked at the instance of the donor. Prescriptive period, 4 years from the time of non-compliance with the condition. The action is transmitted to the heirs of the donor and may be exercised even against the heirs of the donee. It has been held, however, in one case by the Supreme Court, that an action for revocation of the donation based on non-compliance with a condition under Article 764, that 4-year prescriptive period does not apply if there is a stipulation on automatic revocation. So, the 4 years would apply if there is no stipulation on automatic revocation. In connection with revocation of donations based on non-compliance with conditions, you remember some of the cases where, if you look at the facts, there was no strict compliance with the conditions, and yet the Supreme Court did not allow revocation. For example, you have the case of Roman Catholic Bishop of San Pablo. There, a parcel of land was donated to the diocese. The condition of the donation was that that parcel of land was to be used for a home for the aged. The bishop later on realized, before the home for the aged could be put up, that the property donated was not suitable for a home for the aged. Why? Because the adjoining areas were being converted into an industrial zone. So, you can just imagine, pag nilagay mo ang home for the aged dyan, napapaligiran ng mga industries, syempre, lalong madadali ang buhay ng mga matatandang ilalagay mo dyan. When you're thinking of a home for the aged, you would ordinarily think of a place which is peaceful, serene, di ba? Magandang hangin. Hindi yung right in the middle of an industrial zone. So what the bishop did was, instead of using that property for the home for the aged, the bishop decided to put up that home for the aged somewhere else. Ang ginawa ng bishop, the property was instead leased to a third person. There was an action for the revocation of the donation on the ground of non-compliance with the condition. Sabi ng Supreme Court, if you look at it, the bishop was really trying to comply with the condition the best way he could. So, action for revocation would not prosper. All right. In another case, parcel of land was donated to a certain school. Ang condition was that the land would be used exclusively for school building. All right. Ang problema, there was a certain type of school building na the government itself, hindi pwedeng itayo itong school building na dito sa loteng ito. Because for this type of school building, we need at least 1 hectare, I think. Hindi pwedeng dito lang. So, the property was exchanged with another property. Doon na itayo yung school building. Again, there was an attempt to revoke the donation. Failure to comply with condition. Sabi ng Supreme Court, again, what was done was precisely in accordance with the general purpose of the donation. So, what we can possibly glean from this case is that as long as the action taken, while not strictly speaking, is a literal compliance with the condition, as long as the purpose is maintained, the objective is maintained, that will not be considered as sufficient basis for revoking the donation. Still in connection with revocation of donations, you remember that case yung sa nangyari sa Cebu, yung Central Philippine University case. Property was donated to that university. Ang condition, the university should put up a medical school in honor of the donor. Around 50 years later, the heirs of the donor filed an action to revoke the donation because of non-compliance with the condition. Sabi ng Supreme Court, walang duda. There can be no doubt that more than enough time has passed Almost half a century has passed. The condition has remained unfulfilled. There is therefore no longer any judicial obstacle to the revocation of the donation. Of course, there was a rather strong dissent coming from Chief Justice Davide in that case. Sabi niya, dapat there should be a time set first for compliance. But the majority said, wala na. Imagine naman, 50 anyos na lumipas hanggang ngayon di pa nakukumplay ang kondisyon na yan. Kailan pa yan? Alright. Remember the instances when a donation may be revoked due to ingratitude. If the donee commits an offense against the person, honor, or property of the donor or of his spouse or children under his parental authority. If the donee imputes to the donor any criminal offense or any act involving moral turpitude, even if he should prove it, kahit na totoo, unless the crime or the act was committed against the donee himself, spouse, or children under parental authority. And third situation of ingratitude, if the donee without justifiable cause refuses to support the donor when he is legally or morally obligated to give such support. Ingratitude is something which is personal. In other words, it must be the donee himself who must have committed these acts. If these acts were committed by the wife of the donee, hindi ang kasali. Ingratitude is personal. Remember that if the action is based on ingratitude, it cannot be renounced in advance. It prescribes within a short period of just 1 year from the time that the donor has knowledge of the act of ingratitude, as long as at that time it was possible for him to institute the action. Because of the highly personal nature of ingratitude, you take note of Article 770 also. The action cannot be transmitted to the heirs of the donor, even if the donor should die within the prescriptive period of 1 year. It cannot also be instituted against the heirs of the donee. Of course, if prior to the death of the donee, the case has already been filed by the donor, it will continue. Article 771, 772, 773, this would involve collation. We all know, as we will later on discuss in wills and succession, when a person dies, all gratuitous dispositions, the value of all properties which he had earlier gratuitously disposed of during his lifetime will be added or collated to his estate. If they exceed the free portion, they will be reduced. The purpose is to protect the legitimate of compulsory heirs. Collation, therefore, is only for the benefit of compulsory heirs. It cannot be invoked by persons who are not entitled to any legitimate. A simple illustration will, I suppose, drive home the point. Here is Mr. X. He has 2 children, A and B. Let's assume that in 1975, he donated a parcel of land, donation inter vivos, to his friend F. Let's assume that that land is worth 40,000 at that time, 1975. In 1988, he made another donation inter vivos, this time to his friend G, and the land donated was, at the time, 1988, worth 60,000 pesos. 1975, 1988, X was a multi-millionaire. But when X died in 2005, his gross estate was, let us say, only 100,000. His debts amounted to 800,000. So, more debts than estate. Zero balance. Will A and B inherit anything? Meron pa rin. Why? Because of collation. Remember, A and B are compulsory heirs, entitled to a legitimate. So, we have to collate 40,000, 60,000. So, plus 40, plus 60. After all, there is an estate, 100,000. 100,000 will be the basis for determining the legitimate of A and B. Legitimate nila is, of course, 1/2. 1/2 of 100 is 50. So, they are entitled to a legitimate of 25,000 pesos each. The other 50,000, yan ang ating tinatawag na free portion. Di ba? Now, a donation is considered inofficious if it exceeds the free portion. There are 2 donations, 1975, 1988. Between 2 donations, if the free portion is not sufficient to cover all donations, preference, of course, is given to the earlier donation. Why? Because simple principle, priority in time is priority in right. So, in charging or imputing these two donations against the free portion, uunahin natin yung 40,000 kasi 1975 yun. So, 40,000. Kasya ba sa free portion? Kasya. May sobra pang 10,000. We now go to the next donation, 60,000. Obviously, hindi nakakasya yan kasi 10,000 lang ang natitira. So, it is inofficious up to the extent of 50,000. The donation in favor of G is inofficious to the extent of 50,000. It must be reduced by 50,000. So, anong gagawin sa 50,000? J must return to the estate 50,000. Yun ang ibibigay kay A and B, 25-25, to satisfy their legitimes. Supposing that you are the one to whom this 800,000 peso debt is owed. May pautang ka, 800,000. Can you not run after these properties? The answer is no. Hindi na pwede. Why? You can only run after the donated properties of the donor if they were made in fraud of creditors. Pero sabi natin sa problem, mayaman pa siya nung dinonate niya ito. Moreover, what's the prescriptive period? 4 years lang yan. Katagal-tagal na yan. 2005 na. So, creditors cannot run after these properties. Collation is only for the benefit of compulsory heirs. That's only done to protect their legitimes. That's the thrust of Article 771 up to Article 773.